I rise to resume my comments from earlier on in this debate about the Assisted Reproductive Technology and Surrogacy Bill 2025. And today, Acting President, I call on all members to consider supporting the need for a committee inquiry into this bill. I've already spoken about the complexities of this bill and the significant ethical issues that we are considering today. Specifically, there are three areas of law being combined into one bill: assisted reproductive technology, surrogacy, and posthumous removal of gametes. As a young woman, the changes to our laws around surrogacy are of a particular concern to me. And when it comes to surrogacy, as we've been hearing about over the past few days, there are three main groups of people who have a significant interest in this debate: the intended parents, the surrogate mothers, and the children. As my first participation in a conscience debate, it is wonderful to be able to see our democracy in action, to be in a chamber with 37 members of parliament who come from all different backgrounds, have their own views and their own concerns, things they are passionate about, and we have the opportunity to work together to make sure that we can pass the best laws possible for the sake of our state. I acknowledge the contributions of all members who've already spoken on this debate, and I particularly acknowledge those who've had the courage to speak up about very personal situations. I particularly would like to note the comments of the Honourable Julie Freeman, who is one of the few who so far has touched on the various competing interests of the three different groups of people who are most affected by the surrogacy elements of this bill. But the reality is that in a lot of ways, those interests are not incompatible in terms of what we are passing today and over the next weeks. We do not need to disregard the needs of vulnerable people when considering an expansion of access to surrogacy. Whether or not this place determines to expand access to surrogacy for different intended parents does not mean that we should not be concerned about reducing exploitation of women and protecting children. If anything, the fact that surrogacy could become more common after the passing of this bill means that we should be even more concerned about making sure that appropriate protections are in place to protect the most vulnerable in our society. This bill, in its current form, fails to do that, and that is why there is a need for it to be considered by a committee. One of the major concerns that I've raised around changes in this law is in the area of the current law says that a woman cannot be a surrogate unless she's at least 25 years of age and she's already had a baby. When we look at the age of a surrogate and the fact that this bill says it's fine to reduce that age down to 18, I ask, what do we aspire for in our society? Do we really think that there is a pressing need, that there is an urgent reason why we need to risk the exploitation of vulnerable young women by decreasing this age? No good reason has been provided. And the bad reasons for doing this I will illustrate in two examples. Because young women, high school students, can potentially face exploitation and coercion by decreasing the age to 18. A young woman may be in a situation of financial vulnerability, struggling to support herself, approached with a suggestion that she could assist someone to have a baby via surrogacy, and during that time receive support financially. Now, we know that commercial surrogacy is illegal, but it's not enforced and it's not monitored. The potential negative mental harm that could be suffered by women being taken advantage of in these situations is of great concern. We also have situations where women may be emotionally vulnerable and may feel pressured to enter into a surrogacy arrangement to help out someone that they dearly love, but who are not in a situation where they can fully comprehend the impact it will have on their life. These risks are real and could be very easily addressed. In addition, the requirement being removed that a woman has already given birth to a baby also has not been given any good reason as to why this change is required. And the bad reasons for changing this protection, removing this, are the risks of physical, emotional and psychological harm, which I went through in a large amount of detail in my previous remarks. Again, what are we working towards? What do we aspire for? Do we want the first experience of motherhood for women to be one where they are giving away their baby, when they do not have the prior experience to know what that mother-child bond really feels like? My second area of great concern is around the protection of our children. This bill fails our kids because there is no requirement that anyone involved in this process undergoes a criminal check. We cannot prevent child abuse, but why won't we at least try? Why would any of us choose to turn a blind eye to the risks that are here? There is no good reason not to require criminal checks. It is standard practice. It is a basic requirement. When we look at state involvement in parenting arrangements, in parenting situations, we are duty-bound and honour-bound to do everything we can to protect children. In the adoption system, criminal checks are standard. In the foster system, criminal checks are standard. And we are talking about a situation where a child may be placed with parents who have no biological connection to them. No one here is attacking the good people who open their homes to kids in need through adoption and foster care. No one here is attacking individual people or groups of people by calling for criminal checks. The only people we are attacking is those who wish to abuse children. And I have gone through cases in my earlier remarks of pedophiles accessing children through surrogacy and committing heinous crimes, heinous abuse against them. We cannot eliminate these situations, but why won't we at least try? This bill fails our kids, and a simple change could result in reducing child sexual abuse. This bill should be considered by a committee. There are broader concerns that this bill raises that have also not been addressed, and we really have not had the time to seriously consider the issues around commercial surrogacy. Our Australian federal government website on surrogacy clearly outlines why commercial surrogacy is unacceptable, because it can lead to exploitation of women and children. Both our Australian Federal Parliament and the United Nations have published many reports on the issues, concerns and human rights risks that have arisen from commercial surrogacy. And the reality is that commercial surrogacy, while illegal, is not being enforced. Those laws are not being enforced under our current law. They will not be adequately enforced under our bill before us today if it's passed in its current form. And we should be considering greater protections to ensure that commercial surrogacy is not occurring, to ensure that laws against commercial surrogacy are enforced to try and prevent the exploitation of women and children. And specific issues that have been raised in this specifically refer to human trafficking that happens overseas, children left parentless and sometimes stateless, parents also discovering errors in which material has been used and experiencing difficulties with laws around the statehood of their children. Another serious ethical consideration that we have before us in the bill today that has not been debated in detail to any degree is around the posthumous removal of gametes. This is a major ethical consideration and a huge change to our law. But people don't know that it's in the bill. The average person you talk to has no idea that this significant issue, this significant ethical consideration, that the law is being changed in this space. Now, there's not much research in this space, but there is some from the Ethics Committee of the American Society for Reproductive Medicine, who found that in various studies, about half the population supported the idea of posthumous removal of gametes, but of those in support, the majority, a significant majority, believe that the posthumous use of gametes is permissible only with prior informed consent. This issue has not been debated, it hasn't been discussed. We really do not have enough information to go and pass such sweeping changes. In the limited time remaining, I will quickly run through all the concerns that have been raised about the bill before us. And for the following reasons, Acting President, I urge members to support the referral of this bill to a committee for inquiry. The complexity of the law justifies a referral. The fact that both previous bills relating to surrogacy that have come before the West Australian Parliament have been to a committee justifies a referral. The fact that the Australian Law Reform Commission right now is in the middle of a major review of surrogacy provisions around the whole country justifies referral of this to a committee inquiry. This provision, this bill before us, has a complete upheaval of the approval system, completely replacing the Reproductive Technology Council with a completely different body, with a completely different function. The oversight provisions are being removed. The law fails to stop commercial surrogacy. It fails to make it properly enforceable. There's inadequate consideration of the concerns raised by surrogates around the non-disclosure agreement requirements. The bill before us allows advertising for surrogates. It ignores the lived experiences and serious concerns raised by those who've experienced surrogacy and forced adoption. It fails to protect our women. It removes the protection of having had a baby before becoming a surrogate. It lowers the age from 25 to 18. There is no good reason that has been given for these. It doesn't put an upper age limit on who intended parents can be. And most critically, it fails to protect our children from predators. I'd like to give a voice to a survivor of forced adoption who has raised significant concerns around surrogacy, who has said that adoptees are survivors of the permanent consequences of this pre-verbal mother rupture, along with the erasure of our real identity and genealogical bewilderment. Much of the lived experience of adoptees and those born to surrogate mothers is disenfranchised by a society that refuses to believe there is absolutely no consequence to permanently removing newborns from their mothers. Acting President, for these reasons, all of these reasons that I've outlined today, I respectfully ask all members to seriously consider supporting a referral of this bill to committee. And I move without notice that the Assisted Reproductive Technology and Surrogacy Bill 2025 be discharged and referred to the Standing Committee on Legislation for consideration and report.